Welcome, everybody. Thank you for joining me today. I hope you're having a great day. I'm Bobby Futch with Guardian Investment Advisors, and today we're going to talk about some estate planning. Exciting stuff. So sit down, get a cup of coffee, soda pop, and let's have a good conversation. Let's get started.
You're on it. It's already on. You're good. You're keyed in.
We're going to have a couple of conversations today. We're going to talk about, first off, what is estate planning? Who should have an estate plan? What actually makes up an estate plan? A lot of people think that an estate plan is simply a will. That's an important piece of it, but there's so much more to it. So we'll have that discussion. We'll talk about estate administration and probate. Really, that's the big deal about having a well put together estate plan, is to have it properly administered and potentially to avoid probate if that's something that's important to you. And then finally, we'll talk about some taxes that are involved with estate planning. Here's some important questions to ask yourself when you start this process. Do you have a will? Do you have a trust? What about power of attorneys or a HIPAA waiver? All very important parts of a well-constructed estate plan. And even if you do have these documents in place, it's always important to make sure that they are fresh, right? I'd suggest you look at them about every 3 years at a minimum, or if you have any life changes. Deaths in the family, births in the family, you've gotten married, unfortunately if you've gotten divorced. Those are key points in time where you need to go ahead and dust those documents off, take a look at them, and see that they still work out the way that you have intended. Estate planning is really the process of mapping out what happens to all your stuff and financial assets after you pass away. That's a big part of it. Another important, often overlooked part of estate planning is the documents, the power of attorneys, the advance directives for health care that are used and in place while you're living, right? They could be almost as important as a will to help guide your family and help give them the permissions they need to take care of you if you should be in the hospital, if you should be incapacitated and can't do those things yourself. Common goals of estate planning, you want to make sure that your assets go where you want them to go after you're done using them. You can pass those assets to people or entities. Charitable planning is a big part of estate planning if you're so inclined, and we'll talk about that. It can help minimize or eliminate taxes if properly put together. And it can really make administrative costs, which we'll talk about here in a little bit, much less if it's put together in a proper way. It can also help you address a lot of special circumstances in your family. If you have some disabilities in your family, if you have minors, it's really important to do estate planning, just in case you have some minors that are going to get your assets when you pass. If you pass assets to somebody who's under the age of majority, which is 18 in most jurisdictions, it can cause some complications if not handled properly. It can also help people that are unable to manage their own affairs for any reason. If you have beneficiaries that are struggling with addiction or mental illness, and it can also help those folks out, if done properly, if they are going to look to government assistance, Medicaid, TennCare, that sort of thing. You would hate to have those beneficiaries receive assets and mess up those benefit programs. So if done properly, they can have your assets that help support them along with some governmental assistance. You just have to make sure you plan properly. Why should you have an estate plan? This is a really important thing because of all the reasons we talked about. Everything you own is included in your estate. So personal property, personal residence, RVs, boats, bank accounts, brokerage accounts, literally everything you own is going to be in your estate. It doesn't have to be just a financial asset. A lot of people overlook the personal property, real property, and residences, those sorts of things that need to be handled in an effective way during your estate administration. So just think about everything you own now, whether you can put your hands on it or not, that will be included in your estate. Why have an estate plan? Estate plans are really important because it can help, along with all the other reasons listed on these slides, one of the most important and often overlooked is it helps family harmony. I've been in the estate administration business in a previous life for the better part of a decade. And it's amazing what happens to families once mom or dad or grandpa passes away. Uh, and there's some infighting, and it's never what you think it's going to be. You know, you could have a multi-million-dollar estate, and beneficiaries get upset about grandma's candlesticks, right? You just got to make sure that it's taken care of, because once you're no longer there to take care of things and manage things, odd things tend to happen. This is an important one. Is there anybody that should not have an estate plan? Absolutely not. Everybody should have an estate plan. It doesn't have to be complicated. It doesn't have to involve a 20-page will and trust documents, but everyone should have an estate plan. Let's talk about what makes up an estate plan. They should talk about the disposition of your assets as well as how you would want things handled from a financial standpoint and a medical standpoint if you're still living. Again, I mentioned earlier that an often overlooked part of estate planning is financial power of attorneys and advanced directives or medical power of attorneys. And those are the items that really help your family once you no longer can do that. So everyone has an estate plan, whether you know it or not. If you haven't done a will, you haven't done a trust, your state has one for you. You can look up what intestacy laws are in your state, and they will give guidance. Oftentimes that's convoluted, and it's not going to be what you want to have happen with your assets when you pass. So make sure that if you don't want the plan that Uncle Sam has for you, you sit down with an attorney, come have a conversation with us, and let's get your plan put together. If you don't have a will, the court always has to get involved through the probate process to make sure that your assets go to who they think they should go to. A big deal about this is whenever you go through probate, whether it's under the government plan or whether it's under a will that you have drafted, is that your accounts are going to be frozen. That when you pass away, your bank is going to lock down your accounts. Your family's not going to be able to access those documents until they've gone through the probate process. That can cause a lot of problems. If you don't have a will, an attorney is going to have to be hired to do the probate administration process with the probate court in the county in which you live. And it can take a long time. It can take a really long time. You know, estates, it's not uncommon for more complicated estates to take 3, 4, 5 years to administer. And in some cases, estates are never closed. And so I don't want you to fall into that trap of having assets locked up that your family needs and have to go through that process of unlocking those assets with the court when they should be taking their time grieving for the loss of a loved one. I'll also point out that if you have the probate process is a public process. A lot of people don't know that, and it causes some issues because here in the state of Tennessee, state of Georgia is the same way. If a will is probated, it becomes a public document, and you can go down there and pay a small fee and get anybody's will that's passed away in that jurisdiction. And it's going to show exactly what happened with your assets and who got those assets. Oftentimes people don't want to do that, and that privacy issue can be avoided by not going through probate. We talked a little bit about trusts earlier, and a popular trust that a lot of folks are using is what's called a revocable living trust. This is a great document and a great planning process that allows assets to stay unfrozen. They can avoid probate, and you can make almost any kind of the trust can do a lot more than just distribute assets. It can distribute assets in unlike amounts. It can leave those assets in trust to care for your beneficiaries so they don't receive those assets outright. That can be really important if you have a minor, again, like I talked about earlier. You have somebody that may not be able to care for themselves, or you're in a special situation, again, where you have a beneficiary that's on government assistance programs, and getting assets outright to them might jeopardize those assets. So again, a revocable living trust is great. And the cool thing about this is because it's not a will and not part of the probate process, the trust is a private document. So a lot of people really like the privacy that comes from revocable living trust planning. Last will and testament, everybody knows what a will is, been around for thousands of years, and it's really the cornerstone of the estate planning process. The will simply says what you want to have happen with your stuff after you pass away. It doesn't have to be complicated, but again, it is the cornerstone of planning. Even if you have a trust, it's often paired with a will to make sure that if there's any assets that aren't owned by that trust, when you pass away, that those assets get funneled to your trust. Determining if a will is right for you, this is really important. Like I said earlier, everybody should have a will just as kind of a stopgap in the estate planning in case your trust isn't funded. They make sure that the assets go to who you want them to go. It avoids disputes. It can have some tax advantages to it. And it clarifies the duties of the folks that are supposed to help you after you pass away. This is the document that names your executor. They're in charge of all your probate assets after you pass away and getting them to where they need to be. Again, some disadvantages. The probate process is never a fun one. It doesn't have to be complicated. But again, it's something that if you can avoid it, it's a great thing to do. Probate fees. Some jurisdictions do have probate fees. The state of Florida is notorious for this. There's no state income tax in Florida. So the state will actually charge probate taxes, and it's a percentage of your probate estate after you pass. So again, by having non-probate assets, you can avoid that. But know that if you go through the probate process, your jurisdiction may have additional fees. There's also court oversight. That the probate judge in your jurisdiction will make sure that your executor is doing the right thing, but they have to check in with the probate judge at certain points in time. And listen, it's just a hassle, right? So if that can be avoided, that's a great point for a will. And it does take some time. Probating a will through the courts, it's not a quick thing. Even if you have a relatively simple estate, you still have to go hire a lawyer. You still have to go sit down in front of a probate judge and open the estate. You still have to do accounting with the probate judge, and then you have to get dismissed. You know, that could take months if it's done efficiently. It can take years if it's a complicated situation. So that's one of the downsides of a will, and we'll talk about how to avoid some of those things here in a little bit. A trust is a really simple document. A lot of people get hung up and think trusts are complicated. They can be. They don't have to be all of the time. But there's a trust is simply an entity you create, either in life. We talked about the revocable living trust a little bit ago, or a testamentary trust that can be created through a will after your passing. We're not going to touch on the third part a whole lot today, but you can certainly set up an irrevocable trust while you're living. We'll touch on it, but that is more of an advanced estate planning technique that a lot of folks use if they are if they have so many assets that they can run into estate tax issues. We'll see that number is quite big a little later. So there's not a whole lot of folks that benefit from irrevocable trust planning. There's three parties in any trust, and those are the grantor, the trustee, and the beneficiaries. So the grantor is the one that puts the trust together and funds it. And so if you're using the revocable trust strategy, you're going to be the grantor because you're going to put assets into that trust. The trustee is the party that is mandated to care for those assets in the trust. And of course, the beneficiaries are the ones that will get those assets or benefit from those assets in the trust. Interesting point with the revocable trust strategy, if you put one in place while you're living, all three of those roles are you, right? You're the grantor. You put your assets in the trust. You're the trustee that controls those assets, and you're the initial beneficiary as well. Now, those roles will change when you pass, but the neat thing about the revocable trust strategy is because you're all three of those, administration of those assets put in a revocable living trust doesn't change just because they're in a trust. Is a trust right for you? It really depends. Everybody's situation is different. I'd love to have a conversation about your specific scenario, But some advantages of the trust, like we talked about earlier, beneficiaries can get at those assets quicker than if they're in probate. You have control over those assets even after you pass. It can protect from creditors, which is a big deal. And then the inter vivos trust or irrevocable living trust that we talked about avoids probate. And anytime you can avoid probate, in my mind, that's a win. Some disadvantages, changing trustees can be difficult at times if that comes up. Fees to set up a trust, or it's more expensive than just a will. You're going to have a lawyer draft those documents for you in addition to a will, so the cost is up there. There is additional cost to administer trust as you move forward. It's not as cheap as just having those assets in your individual name. But again, with the revocable living trust, that doesn't really apply until after you pass. And then this is a huge one, and where financial planners really add value to the estate planning process. I've seen this countless times where somebody will go to an attorney, draft an estate planning document, great documents, but they're never funded. Assets are never placed in the trust. And oftentimes the attorneys are there to help draft the legal documents and put a plan in place. They don't help fund a trust. So you can go through all the planning, have a great will, a great trust in place, but if it's never funded, it's as if you've never done it. So if you have a trust in place now as part of your estate planning strategy, listen, give me a call. I can help you make sure that those assets are titled properly so they're actually owned by your trust. Very important point to make. There's a handful of different trusts. We talked about the revocable living trust, which is a very popular strategy, but you also have marital trusts, credit shelter trusts. Those are generally created through your will, and that strategy is used if you are in excess of the state tax exemption, which is currently now at $13.9 million. So again, those numbers, the estate tax exemption numbers used to be much, much lower than they are now. And oftentimes you'd find yourself paying estate tax simply if you had a 401k and owned your home. That's generally not the case anymore, so you're not seeing these marital and credit shelter trusts set up as often, but it's a very important tool to use if you are in that bucket. You also have a children's trust. This is a really broad term that just means a trust for somebody that's put in place when they're a minor. And so if minors in your jurisdiction, usually 18, but it can change in your jurisdiction, some states are 21, if assets are passed directly to a minor and they're not of the age of majority, there's going to be court oversight on those assets. They're going to have a guardian named for those assets, and they'll have to check in with the judge often. That can be prevented using a children's trust, and those assets will stay in trust, not owned by those minors until they're either 18 or 21. And then there's also a special needs trust or a supplemental needs trust. If you have a beneficiary that has a condition where they are on government assistance programs, and those are really valuable to a lot of folks, you would hate to jeopardize those benefits by leaving assets outright to them. So a supplemental or special needs trust can be a really important tool in helping plan for those folks. How is a revocable living trust avoids probate? How does it avoid probate? Because your trust never passes away, right? When somebody passes away, that's what starts the probate process. But if your assets are owned by a trust, they continue to be administered just like they would with if you had not passed away. An important part of a revocable trust strategy, because you are the grantor, because you are the trustee, and because you are the initial beneficiaries of your revocable trust, it is not a tax planning strategy. Those assets will be taxed just as if you owned them. So that's important. And that's really something that a revocable living trust has, and those permanent or irrevocable trusts, it's a big difference. An irrevocable trust can help you save on estate taxes if properly done. And so we talked a little bit about this. A revocable living trust and an irrevocable trust both help you avoid probate. But with the revocable trust, because you're all three of those roles in that trust, you're in control of those assets 100%. Assets are taken out of your left pocket, put in your right pocket. You own them as an individual first, and then you own them as a trustee second. And this will become irrevocable at your passing. So you're free to change that trust as often and as many times as you want while you're living. But once you pass away, that trust becomes irrevocable, and another trustee steps in to administer those assets for your successor beneficiaries. An irrevocable trust, just as it sounds, is very, very difficult to change. If you're going to put an irrevocable trust strategy in place, I would suggest you put the thought into it and go through that process thinking in your mind that this trust cannot be adjusted, because it's very difficult to do so and involves the courts. Here, this is the most often overlooked part of an estate plan, and I would argue one of the most important. We're going to talk about power of attorneys. There's two types of power of attorneys. There's the financial power of attorney, which we're going to talk about first. And you really want to think about, when is this document going to be effective? And what I mean by that is you can draft a power of attorney that's effective now, right? If you wanted to have a power of attorney and name your spouse, and it's a durable power of attorney is what it's called, they can act on your behalf immediately, and you don't have to be sick or disabled. So you need to make sure, if you have a durable financial power of attorney, that you trust your agent, and be very, very careful and thoughtful about what powers you give that agent. An advanced healthcare directive, or a medical power of attorney and living will is what it used to be called, is the document that allows somebody to make medical decisions on your behalf when you can't do that. So the appointment of that person is very important. Also, what this does, and which I think is vitally important, is gives that agent, which generally is a family member, directions on the decisions you would want to have made if you can't make those medical decisions for yourself. I've seen it a handful of times where mom, dad, end of life scenario, they can't make their decisions, and the family is wondering what decision mom or dad would want to have made, right? You're not in a good spot, and now your family has that added stress of trying to figure out what you want. An advanced directive or living will tell them exactly what you want to have done and what decisions you want to have made. So it's really, really important to have this done. Beneficiary designated assets, generally life insurance, retirement accounts, IRAs, 401ks, 403bs, they have beneficiary designations on them. Because they have beneficiary designations on them, they're not a probate asset, and so they can go to those beneficiaries a lot quicker and sometimes more efficiently than they would if they were a probate asset. The disadvantage to this is you want to make sure, as you have life changes, that you update your beneficiary designations. If you have an ex-spouse and you don't update your beneficiary designation, there's a very real chance that that person has the legal right to those accounts after you pass, and it's very hard for your children or your new spouse to contest those beneficiary designations. We talk about estate administration a little bit. This is the probate process that we talked about earlier. It differs from jurisdiction to jurisdiction, but generally you're going to have to go to the probate court and file the will, and you'll have to use an attorney to do that. Costs vary wildly in this. You're going to have to pay an attorney to do it. You're going to have to pay the probate court. If you have any real property or valuable personal property, you'll need to get an appraisal. You can run into estate taxes. Your estate will pay income taxes, and all of these other things here listed. There's a lot that goes into estate administration costs that a lot of people overlook, and that's one of the big reasons why a lot of people go out of their way to make sure they either don't have a probate estate at all, or that probate estate is very small. Can it be avoided? Of course it can. We talked a little bit about these earlier. A well-constructed estate plan can avoid probate. Some of the ways that probate can be avoided is jointly owned property. If you have a husband and wife on a bank account or a deed, if done properly, that asset becomes theirs automatically at your passing and avoids probate. Again, beneficiary designations and trusts can do the same thing. And so now we have here just a little chart that talks about what probate property would be versus non-probate property. Let's have this conversation. If you're concerned with this, give us a call here and we can help you walk through this. What happens if you die without a will? This is a big one that a lot of people ask. Your assets don't go to the government. That's a misconception that a lot of people have. If you die without a will, Uncle Sam is not going to take all your property. but they do have intestacy laws in place that say who gets what. And oftentimes, if you have a surviving spouse, it's this way in Tennessee, you will have your spouse get a certain percentage of your assets, and then your kids will also get a certain percentage of your assets. And that can cause some issues. You know, the kids feel bad that they're taking money out of mom's pocket. Mom may have needed those assets for the remainder of her life to live out her life. And now you've got a situation where the kids are having to pay some of mom's expenses because dad didn't have a will. We talked a little bit about this. Dying without a will is called dying intestate, and that's no will. You can also have a will, or generally a better option is a revocable living trust. The will still probates, right? Fairly simple to set up. You can hire a lawyer to do that. There are online tools that you can use to do your own will. Most jurisdictions do allow you to write your own will, but again, it goes into effect after you die, and it goes through that probate process. We talked about this a little bit earlier about potential issues with intestacy laws, and here's a neat graphic that kind of shows how it would work if you die without a will. The surviving spouse in our example here would get 1/3, and the 2 children would get the same share. Beneficiary designations can avoid that. Why most do nothing? It's just procrastination. Listen, I understand it's not an easy conversation to have with your spouse and with your family, and talking about death is uncomfortable. But really, once I help clients go through this process and we get an estate plan set up, it's a sigh of relief. It's a weight off their shoulders, knowing that, God forbid, should something happen or when something happens, it's taken care of. It can be expensive if you get complicated, but oftentimes it's not. Time-consuming process, unsure what to do, those things are true. But let's sit down and have a conversation about your particular situation, and I can help walk you through that process. So by the time you get to an attorney to draft these documents, a lot of the heavy lifting is done. So you have choices. You can do nothing. We talked about the issues with doing nothing. You can hire an attorney to do that, or you can do a DIY. There's a lot of really good examples or services online that can help you do it yourself if that's the route you want to go. Let's talk about death and transfer taxes, because a lot of people, there's a lot of misunderstanding about these taxes. So you have really 4 types of tax when somebody passes away. You have federal gift tax, that and the federal estate tax are now lumped together. So I mentioned earlier you have call it $14 million, $13.99 million that you can individually pass to anybody during your lifetime or at death before estate taxes become an issue. Estate taxes now under the current estate tax regime are also portable. And so if the first spouse to die doesn't use all $13.99 million of their estate tax exemption, they can pass that to their spouse. So really, you would have to have a joint net worth approaching $28 million as a married couple before that becomes an issue. Generation skipping transfer tax is one that is often overlooked and can be important if you're looking to skip a generation and, say, leave assets to your grandchildren. There's actually a separate tax regime for that if you want to skip generations. Again, these taxes are fairly punitive at 40% once you get over that $14 million mark. And so if you're in that situation, it's really important that you sit down with a financial planner and an estate and tax attorney to make sure you're set up to avoid and minimize those taxes if at all possible. And then some states have their own estate tax. It varies wildly among states, but not only might you have to pay Uncle Sam when you pass, but you might have to pay your state government as well. Are received assets taxable? A lot of people ask, if I pass an asset to a beneficiary, do they have to pay taxes on that? No, the gifting of property through an estate is not a taxable event. Now, once they get that asset, and if they receive any income off of that asset, they will have to pay income taxes on it, but simply because they received an asset doesn't mean they have to pay taxes on it. A really important thing to also know, if you have a capital asset, if you have real estate, if you have stocks, those assets have what's called a cost basis. And when they're sold, you calculate the capital gain from what you sold it for take off your basis, and that gain is what you pay your capital gains tax on. I'm sure a lot of people here are familiar with it. The neat thing about receiving an asset through an estate is that the receiver's or the beneficiary's cost basis adjusts to the value of that property on your day of death. So if you have a home that's worth $500,000, you paid $250,000 for it. If you sold that asset, you would owe capital gains tax on the difference, $250,000. Now, there are some exceptions for primary residences, but let's throw that out for the sake of our conversation. If you were to give that asset to your beneficiary, their new basis would be $500,000 in that home. So if they turned around and sold it in short order, it's very possible that they wouldn't own any capital gains on that asset. So a lot of people want to gift assets while they're living. If you gift an asset while you're living, they also receive your cost basis. That's a very important part. If you give something while you're living, your cost basis transfers to them. If they receive it because you pass away, they get a new cost basis. There are some ways to avoid federal estate income taxes, and we can talk about some of those. But that's a deep conversation. So if you're worried about estate taxes, give me a call. I'd love to have a conversation with you. There's no obligation. I hope you got some information out of this today, and I look forward to seeing you later.